Hello, everybody. It's wonderful that so many of you have joined us for PET's first online event, More Trouble in Store, the 2-year extension to embryo and gamete storage. I'm Sarah Norcross, and I'm the Director of Progress Educational Trust, PET, a charity which aims to improve choices for people who are affected by infertility and genetic conditions. To the event in hand, More Trouble in Store, the 2-year extension to embryo and gamete storage limits. So all UK fertility treatment was suspended earlier this year due to the coronavirus pandemic, and the resumption of fertility treatment remains challenging even now. Patients for whom the 10-year limit was imminent when treatment was halted were faced with the very distressing prospect of seeing their gametes or embryos destroyed before they could be used in treatment. And just the uncertainty around all that is extremely distressing. Additionally, the pandemic has caused problems for researchers in life science and biomedicine who have been unable to potentially get into their labs and who use gametes and embryos for their research. So to address this problem, the UK government introduced some new regulations which came into force at the beginning of this month, granting a temporary 2-year extension to the 10-year legal limit. And I'm sure that, like many of us, you were delighted by this. We were particularly pleased because we see it as a bridge to our call for reform of the 10-year limit for social egg freezing. And quick plug, if you haven't signed our petition yet, please do so. We're getting very close to 1,000 now, so it'd be great. So please sign and share. Now, we've done events on storage before because the law in this area can be forbiddingly complex, and even before the new regulations are taken into account. And so when I started to get questions from people about the new regulations, we thought this is a good topic for an event. And so to help provide clarity, we will hear from the legal expert, James Lawford Davies. Now, James is a solicitor and a partner at Hill Dickinson in London, and he's also an honorary lecturer at UCL. He advises a large number of clinics, hospitals, universities and researchers licensed by the Human Fertilisation and Embryology Authority, the Human Tissue Authority and the Care Quality Commission. And he's been involved in most of the leading cases relating to assisted reproduction and embryo and stem cell research. He's been involved in cases at every level in the UK courts. And much of his work has involved judicial review of regulatory bodies and cases arising as a result of regulatory action. So I couldn't think of anybody better placed than to talk about this subject. Now, I've known James for a long time, and it's so long, in fact, it seems that I must have known him when he was in short trousers. And of course, on Zoom, we don't know if indeed he's still wearing those short trousers. So on that note, I'm going to stop sharing my screen, and I'm going to hand you over to James Lawford Davies.
Good evening, everyone. I hope you can hear me and see me clearly. It's a very grey, wet evening in North Yorkshire. And I think a common symptom that people have described of lockdown is the difficulty in distinguishing one day or week or month from another. And it certainly doesn't seem that long ago that we were in Edinburgh to talk about the storage regulations at the excellent event that Progress organised there. And I would just like to briefly pay tribute to the work that they've done in this field in moving the debate and the discussion and indeed the law forward to help people who have been put in very difficult situations as a result of the complex and restrictive rules that we have. But as Sarah said, this is a step in the right direction. I must say it is complex. I don't have many slides to go through, and I will endeavour to go through them slowly and carefully. So bear with me, and hopefully we can clarify these rather complex regulations. And then if you do have any questions at the end, then I'll endeavour to answer them. So when we met in Edinburgh, I briefly went through the existing regulations and legislation as they stood. As a brief recap, I'm sure you'll be aware that the overarching legislation that regulates reproductive technologies in the UK is the Human Fertilisation and Embryology Act. And that prohibits the storage of embryos and gametes, except under a licence granted by the regulator, the Human Fertilisation and Embryology Authority. And every licence that the HFEA grants to centres is subject to conditions, and one of those conditions is that embryos and gametes must only be kept for a statutory storage period. It's a term that I'll use innumerable times this evening. And that statutory storage period is usually 10 years. The Act also makes it a requirement that gametes and embryos are only stored where there's effective consent in place for their storage. There have been a series of statutory instruments which have created situations where the storage period can be extended for medical reasons. And the most recent are the 2009 storage regulations, which are still in force. And these allow an extended period of storage for embryos for beyond the statutory 10-year period, where both of the gamete providers whose gametes were used to create the embryos have consented to that extension, and where a medical practitioner has provided a written opinion that one of the gamete providers, or the person to be treated with the embryos, is prematurely infertile, or is likely to become prematurely infertile. And that opinion has to be provided on a day within a relevant period. And again, that's a term that I'll use quite a bit this evening. The relevant period is within the first 10 years of storage, or the 10 years that follow the last medical opinion that's been obtained. So within the first 10 years of the statutory storage period, you have to obtain a medical opinion, and then there are incremental opportunities to extend storage for further 10-year chunks thereafter. And the storage period is calculated from the date that embryos are first placed in storage. Very similar provisions apply to the storage of gametes. So it may be the statutory storage period can be extended beyond 10 years, where the gamete provider has consented and where the medical practitioner has provided a written opinion that they're prematurely infertile or likely to become prematurely infertile. And again, that opinion must be provided within that relevant period, or the first 10 years. So that's the law as it stood before the pandemic and the new regulations. These were drafted earlier this year, and as Sarah touched on, they were implemented to address a range of different problems that affected patients who had material in storage, regardless of whether or not those patients were affected by premature infertility. It was more about addressing this range of situations. So for patients who were unable to access treatment because of the temporary suspension of services, or for patients who were coming to the end of their storage period and not able to extend and obtain the medical opinion, or for a range of other factors which may have affected their ability to have treatment. So these regulations came into force on the 1st of July. These new regulations introduce a range of different opportunities and assistance for patients affected by the pandemic. The first was that I'm going to talk about was the extension of the statutory storage period from 10 years to 12 years in certain defined circumstances. So we're not here talking about premature infertility. This is the statutory storage period that would apply to all patients with material in storage. And for embryos, those defined circumstances are where the embryos are in storage in licensed premises on the 1st of July 2020, and the two people whose gametes were used to create those embryos have consented in writing, either before, on, or after the 1st of July, to storage for that additional 2-year period for 12 years. Similarly for gametes, where gametes are in storage on the 1st of July, and the person who provided the gamete or gametes has consented before, on, or after, then they can remain in storage for 12 years. Now, I usually use a lot of images in my talks. I struggled to find a way to brighten up this presentation on statutory storage periods. So this is a picture of a couple, let's call them Darren and Shirley. To give you a case study to illustrate this extension, Darren and Shirley had embryos created and stored in March 2012 at a licensed centre. They originally consented to the statutory 10-year storage period, but they're able to fulfil the requirements under the 2020 regulations to extend the storage for the additional 2 years. So their statutory storage period can be extended to 12 years. They'll need to consent to that extended period, but they can extend up to a new period taking them to March 2024. The second notable provision in the regulations is to extend the relevant period from 10 to 12 years in certain circumstances. So here we're looking at couples who are or may be affected by premature infertility. There are again very similar provisions covering embryos and gametes. So where embryos are concerned, the maximum storage period has been extended from 10 to 12 years under the 2020 regulations, where that maximum storage has been extended to 12 years. The relevant period, so the period within which the medical practitioner's opinion must be obtained, where the statutory storage period has not previously been extended under the 2009 regulations, then the MPS must be obtained within 12 years from the date that the embryos were first placed in storage. Or if the statutory storage period has previously been extended, then the MPS must be obtained either 12 years from the date of that first storage, or if it's later than that, 10 years from the date of the most recent MPS. So it gives an extra 2 years to obtain the medical practitioner's opinion in relation to premature infertility or likely premature infertility. There are very similar provisions in relation to gametes. So where the maximum storage period has been extended to 12 years, as we've just discussed, then the relevant period within which the patient must obtain a medical practitioner's opinion can also be extended to 12 years. Where the statutory storage period has not previously been extended, then you've got 12 years from the date of first storage, but where it has previously been extended, then it's either 12 years from the original storage, or if later, 10 years from the date of the most recent MPS. So that's to allow those affected by premature infertility or potential premature infertility to have the benefit of 2 more years in which to obtain their medical practitioner's opinion. Here we have Boris and Chantal, who had embryos placed in storage in March 2012. They again originally consented for the standard 10-year statutory storage period, but they're able to satisfy the requirements of the 2020 regulations to extend that standard statutory storage period by 2 years. But Chantal is prematurely infertile. They obtained a medical practitioner's opinion in February 2024, so they are able to extend their storage up to 2034 based on the new regulatory provisions. The last notable development under these new 2020 regulations relates to difficulties in obtaining medical practitioners' opinions as a result of COVID or the lockdown, or any reason relating to coronavirus is the term that's used in the regulations. So for embryos, this gives the gamete providers whose gametes were used to create the embryos an additional 2 years, so taking them to 12 in total, to obtain a medical practitioner's opinion, where an opinion was already in place before the 1st of July 2020, but another opinion can't be obtained by the couple within 10 years from the date of the original or the last medical practitioner's opinion, as is required by the 2009 regulations. And this difficulty in obtaining the opinion must be as a result of a reason relating to coronavirus. It's not a term that's defined, but I'm sure that it will be broadly interpreted, because the intention is to allow for this extension of an additional 2 years for any reason relating to or caused by the pandemic. There are certain conditions that have to be fulfilled in order to obtain this extension. First, the embryo must be stored in licensed premises as of the 1st of July 2020. Second, as I mentioned, there must already be a medical practitioner's opinion in relation to premature infertility, or likely premature infertility. There must be one in place before the 1st of July. Thirdly, the gamete providers or the person that's going to be treated, if they were unable to obtain a medical practitioner's opinion within 10 years from the first opinion as a result of a reason relating to coronavirus, they must have provided their consent, but that consent can be before, on, or after the 1st of July. It doesn't need to be before the 1st of July to the extended storage. And lastly, it can't, the statutory storage period hasn't previously been extended under the new regulation. So it's a one-off extension of an additional 2 years. It can't be used more than once. And there are very similar provisions in place relating to gametes. So I haven't set out those provisions again for gametes. They're essentially the same as the provisions relating to embryos. So here we have, let's say, Brian and Betty. Brian and Betty had embryos placed in storage in March 2002. They consented to 10 years statutory storage period, taking them to 2012. They had a medical practitioner's opinion in 2010, which gives them 10 years, taking them to August 2020. But they were unable to obtain a further medical practitioner's opinion for a reason related to coronavirus during the lockdown in 2020. But they're allowed to take another 2 years, calculated from the date of the last medical practitioner's opinion back in 2010, so they can store and have more time to obtain a further opinion until August 2022. Hopefully that's clear. The HFEA have produced very helpful guidance on the interpretation and the application of the regulations. There are some questions and case studies on the HFEA website. There's also a new coronavirus consent form to allow patients to consent to the extended period if they need to on this particular form. And there are some additional links to other resources that clinics can use, including an optional audit form that can be used to help clinics work through patient scenarios and situations to decide which, if any, of these potential extensions apply. There are some additional points that are worth mentioning and perhaps interesting to think about and maybe discuss when I've stopped talking. The regulations don't apply to material that's been put in storage since the 1st of July. So there is a cutoff as of the start of this month. The second curiosity to my mind is that the regulations do not stipulate that material must be lawfully stored as of the 1st of July 2020 in order to be eligible for extension. And that this at least potentially allows material that has in fact come to the end of its lawful storage period but remains in storage on the 1st of July to have a, if you like, a second bite of the cherry and have extended storage up to 12 years, providing that other requirements can be fulfilled, which is a curiosity of these particular regulations. The third thing that I thought I'd flag up is some advice that's set out in the HFEA's guidance, and that's that they recommend that clinics take all reasonable steps to contact patients whose material that's in place, that's in storage on the 1st of July, to notify them of the regulations and give them the option to extend storage for up to 12 years. And where necessary to complete this new consent form. And I can see, given the potential length of some of these extensions, this is something that clinics are going to have to keep an eye on for quite some time, unless, of course, the law changes in other respects to make broader changes to the storage requirements. So I'm very sorry that there was some difficulties in hearing me. I now feel like I've been shouting for half an hour, but that's all I was planning to say about these new regulations. So if there are questions, then Sarah, we can endeavour to answer them. What I would suggest is that if people have very fact-specific questions about the calculation of storage periods, particularly the historic calculations under the old regulations, I would suggest perhaps writing to me separately to discuss those rather than dealing with them through this medium for two reasons. One is because they are notoriously complicated, and I worry about my mental agility in answering them off the top of my head. And the second is that often the very fact-specific scenarios are of limited interest to other members of the audience. So if you don't mind dropping me a line, then I promise I will get back to you with the very specific questions about calculations. But otherwise, very happy to discuss how the regulations work.
Thank you for that presentation, James. We've had a number of questions, and I shall start to go through them. The first question is from a patient saying, the clinic storing my eggs didn't seek my consent to store my eggs for an extra 2 years. I didn't realise that consent was needed and thought it would apply automatically. I'd like to benefit from the extension. Now that the 1st of July has passed, what can I do?
Well, if the eggs were in storage on the 1st of July, that's what really matters. So the consent to the extended storage can be obtained and given after the 1st of July. What's crucial is that they were in storage on the 1st of July. If they were stored after the 1st of July, then the extension won't be available. But providing they were, then that should be fine.
Okay, and then there's a question from Laura Mason at Hull IVF saying, should clinics be writing to all patients that have gametes and embryos in storage to inform them about this change and offer them the option of an extension with the CVS form where relevant? Because obviously I can imagine for clinics that is quite a big administrative burden, and I had some questions around that. So if you can start on that, James.
Well, it's the last point that I mentioned from the HFEA's guidance, that certainly the recommendation is that all patients who may be eligible for this 2-year extension, whether as a result of premature infertility or not, should be contacted to be given the opportunity. Because we don't know how the pandemic has affected people and how lockdown has affected their decisions or their pressures or their plans or expectations. So that's why the regulations are drafted so broadly to help patients in all sorts of different circumstances. But yeah, I can see that it's an administrative challenge.
And I think, you know, I had some questions over email actually, where people were asking me, you know, what was the best advice for a system for a clinic? And I know you're not an admin person, you're a lawyer, but really, you know, should they be writing to everyone at once, or should they try and triage it so that they do them in chunks, and other legal pitfalls if they think, well, we'll wait till the people now are, say, in year 7 before we write to them about the 2-year consent, because then we might have seen them in the interim anyway, and it just saves us a deluge at the beginning.
Yeah, it's a very good question, and I don't think there's a right answer. I think in terms of where to start, it's though I would suggest the most pressing issue are those who are or who would be without an extension nearing the end of their permitted storage, or and it was a question that's disappeared off the screen, those whose material should have been removed from storage but is still in storage, and was in storage on the 1st of July. So those borderline cases, or those who in fact passed the border, those are the ones logically I would think you should start with. And then, as you say, there's less urgency about patients whose material will be in storage for some time. I think the challenge then, in maybe 8 years' time, will be to work out where we are in terms of how many years are left, and what can then be calculated.
Okay. So yes, the questions are coming thick and fast now, and I have to confess I'm slightly struggling, although some of them are technical things, so I can ignore those. So, so this is anonymous. If a patient's 20-year MPS is due next year, this would remain due unless they provide reasons due to coronavirus why they cannot obtain this. The MPS would not last 12 years by default.
That's right, and there needs to be consent to the extended storage from the patients in all circumstances, but including where the request for the extension is for reasons related to coronavirus.
Now, there's an interesting question from Brian Woodward, and this was something that I jotted down to ask you about, actually, if the questions are thin on the ground. So he's asked, given the current lockdown in Leicester, do you think we can appeal against the 1st of July date if needed? Because obviously we might, whether we have a cross-country lockdown, which we hope is highly unlikely, but local lockdowns may happen. And if it happens in London, where the majority of the clinics are, that's a lot of people potentially affected. But regardless, every patient is important with this. Would we be looking to have to go back to Parliament for a change here, James?
Well, I'm trying to think can you think of an example of the practical problem that the lockdown would cause? Do you mean if patients were unable to store material but would have had material in storage on the 1st of July but for the local lockdown?
Well, I suppose I was thinking about, if you go in store now, I know that's perhaps unlikely if it's not for medical reasons, but if one were able to do that, and then the clinic ended up being closed for a few months, you've had a disruption in your service, that someone else, could have had the similar thing, because they could have frozen just before lockdown for, say, eggs for social reasons, and they'd get a bonus 2 years and you wouldn't, and that would seem a little bit unfair, because you'd have experienced the same period of not being able to be treated.
Yeah, I mean, I understand that the 2-year period was decided on to allow sufficient time for patients to adapt and to adjust their plans, and for clinics to adjust their treatments. I think it might be difficult to get that 1st of July date revisited, but then I suppose we are also hoping that the law will be revisited within the coming years. So hopefully that sort of window will cease to be relevant. But I can see the argument that the same benefit should be given to patients if they've been adversely affected by a local lockdown, but it would require a change to these regulations.
Okay. I think we've sort of dealt with this one, really, and it makes me a bit nervous that this would be the policy. Can clinics wait to close to the expiry, i.e. 9 years, in order to inform patients about their 2-year extension?
Well, they can.
Is it good? Is it good practice then, James? Sorry, would you think that would be good practice? We can do lots of things and we shouldn't do them.
It's rare for clinics to leave it to the last minute. Most clinics have systems in place that ensure that patients are contacted in advance of the expiry of the storage period to allow them sufficient opportunity where possible to obtain a medical practitioner's opinion about their fertility, and again, where possible, to extend further. So it's certainly good practice to try to, and it's sensible to not to leave it to the last minute. It's not a statutory requirement, but it's certainly recommended.
So we have a question next. Do you think that the lacuna that you've identified effectively provides a way around the 10-year rule issue? And that's from Amanda, I think it's Amanda Masson. Apologies if I've not pronounced your name.
Yeah, well, I mean, it's one of the points that I mentioned at the end that I think is curious about the regulations, and that in some ways it's not even a lacuna. It's the regulations are quite clear that that the storage doesn't need to be lawful. The material just needs to be stored in licensed premises. Now, of course, there may be wider regulatory consequences for unlawful storage or storage beyond the consented period or the statutory storage period. But certainly on the face of the regulations, if embryos and gametes are in storage, even if they shouldn't be, then they're eligible for this extension. So yes, it is a temporary solution for certain categories of material.
One thing that I wanted to ask you about, actually, and I'll use my chair's prerogative, is about researchers. And so where they've got materials that have been donated for research, are they going to have to contact all the donors to extend the time period?
Yeah. So the material is still eligible for the extension, but it again the extension has to be consented to. So it doesn't happen automatically. It's something that the donor has to consent to. And similarly with donation as well. If a donor's consented to a period beyond 10 years, then that's fine. But if they've only consented to 10 years and you want to use donated material, then you'd have to go back to them to ask them to consent to the 12-year period.
Okay, now there's a question from Martin Johnson that combines all your, some of your areas of expertise in one. What if one partner has died since the original consent was signed? And also you were a big player in the Beth Warren case. You did that. Are you involved in that?
Well, it's a classic lawyer's answer, but it depends. So it depends on quite a wide range of things, and particularly what the deceased partner consented to during their lifetime. And so if there is consent to posthumous use, then the material can be used in accordance with that. But it won't be possible to obtain further consent to the extended storage period. Although if the material is in storage on the 1st of July, then the basic extension for 12 years will be eligible in certain circumstances, but not in relation to material that, where it's impossible to obtain extended consent. So it's a tricky one, but it'll be quite fact specific. I don't think I answered that very clearly, but it will depend on the circumstances of the case.
I think you answered like a lawyer, and I say that as a compliment, being a I was about to say reformed lawyer, but no, I'm a lapsed lawyer in recovery. So yeah, now we've had a comment in the Q&A from the HFEA about this, to give the HFEA's official line on clinics contacting patients, and that is that it's a local decision as to when clinics decide to contact their patients to tell them about the possibility of extension. They may choose to do this now or when the patients are nearing the end of their initial storage period. Sometimes it can be challenging to contact patients, and this should be taken into account when centres decide when to contact patients about this complex consenting situation, so as to ensure effective storage consent is continuously documented for all samples stored. Patients who may have been affected by clinic closures should be prioritised. So thanks to the HFEA for chipping in there.
Very well put.
Yeah, well, not very well read though, but there we go. Right, I'm trying to look for a slightly different question. So
we answer Natalie's question.
yes, yes, and so Natalie's question is: do you think that this is all just adding another layer of complexity to already complex rules, as well as the administrative nightmare for clinics? If so,
Yes.
we hope that the government will soon just abolish all the statutory storage periods. Anyway, I'll let you answer, James.
Well, yes, I already have. I think I did my best to explain them, but even as I was talking, I was conscious that it's just a very, very difficult topic to explain, and I think the department have done an excellent job with what they've got and to address a really difficult situation. But the reality is, it's a minefield and it is extremely complex. And I hope, Sarah, that the next time, if you ever ask me to speak at a Progress event again, you'll give me something really sexy to talk about, like data protection, rather than statutory storage periods, which is rapidly becoming my least favourite topic.
I've actually got a personal thing about data protection with a doctor, so perhaps we'll be chatting offline about that. There's a question from Raj Mathur. If embryos don't have to be lawfully stored on the 1st of July 2020, is there a limit for how long over the storage limit they can be?
Well, yes. So the potential extension under the regulations is for the maximum of 12 years. And so it doesn't go beyond that. So if you have material that's been in storage way beyond the consented period or the statutory storage period, then you'll already be, if it's 13 years, then you'll already be beyond what you could take advantage of under these new regulations. But if you had material, let's say the storage expired in January this year, and for whatever reason it remains in storage as of the 1st of July, then that could take advantage of the extension. But if it's really, really old, then it can't.
Okay. I'm going to flit about and move to one. This again involves where a partner has died. So if a partner dies between now and the clinic offering an extension, could the clinic be found at fault for not offering the extension sooner? Thanks, they say. So, tricky.
Yeah, it's an interesting question. I mean, I think it goes back to this local decision about how you approach this. And of course, in most situations, there may be no reason at all to be concerned about illness or unpredictable death. So I don't know if a clinic could be fairly criticised if there was no reason to be concerned about the health of their patients for not offering it now, because it is something that can be applied further down the line. But certainly where there is any concern about patients who've been unwell or may be unwell, then they could be prioritised as well. But I would hope that clinics will be prompt in dealing with this, but it's not something that they can deal with immediately for all patients who have material in storage on a what is often a very large scale.
Yes. I think it's that I would imagine that for those working in clinics, it's the scale of this, that especially when they're not back fully operational is the real challenge. So we have a question from Sharon Jones, who's been the face of our campaign for Extend the Limit. And she said, sorry if I've missed this, but I'm no clearer on what the rules are for egg storage periods for social egg freezers as a result of the coronavirus extension. What medical opinion do I need to obtain? How and what can be considered as a related to coronavirus reason? So I think if you could take that one, James.
Well, if it's for social egg freezing, non-medical reasons, then the eggs are in storage on the 1st of July, then providing the patient consents, they can extend for an additional 2 years. So hopefully that's clear. In terms of medical opinions, you don't need to obtain a medical opinion to take advantage of that simple 2-year extension. But if you wish to extend beyond 10 or 12 years, then for medical reasons, then you need your medical practitioner's opinion. But if it's for social storage, I don't particularly like the term, but the non-medical reasons, then you don't need a medical practitioner's opinion to store for 12 years. The regulations allow you to do that, providing you consent.
It's what I thought was the case, but as I keep saying, lapsed lawyer, don't take my word for it. So
the issue about a reason related to coronavirus is only relevant where you've been unable to obtain a medical practitioner's opinion due to a reason related to coronavirus. So where you would be eligible to extend storage, either for the second or third time beyond the first time that you've had a medical practitioner's opinion, if you couldn't obtain your next medical practitioner's opinion to extend again, then you can rely on the regulations for a reason related to coronavirus.
Catherine Drennan from the HFEA has posted, I think, a similar response in the Q&A, so that it's. I think you've covered that quite clearly now, James. So we'll perhaps move on to another question. Will donor banks need to contact the clinics to inform them if a donor sample has been stored for an additional 2 years? Or how would a clinic know when to discard donor sperm?
Well, unless the donor, there's 2 different questions. Unless the donor consents to the additional 2 years, then they can't be kept for a longer period. So it's not an automatic extension without their consent. In terms of whether the bank needs to contact the clinic, I'm not. And the question's disputed.
I'm sorry, James.
I'm not sure what the question is there, but I'm happy to come back to it if someone wants to. If you want to let me know what the question is, I'm not quite sure what the.
Or how would a clinic know when to discard the sperm was the second bit of it. So will donor banks contact the clinic to inform them if a donor sample has been stored for additional 2 years, or how would a clinic know when to discard the donor sperm?
Yeah, well, the donor would have to extend, and if they've extended, then I suppose there may be reasons for the bank to let the clinic know that the sperm is available for a longer period, but it can only be kept for a longer period with the donor's consent.
Okay, I'm going to take another question from Raj, a sort of a technical legal question in a way. Is it the law that we need to offer extension to all patients with stored gametes, or is it just something the HFEA would like clinics to do, or as we were sort of saying, or that they should do, rather than they must do?
Well, it's an interesting question. It's well, the regulations create an opportunity, they don't impose a requirement. So the regulations don't require clinics to contact patients, but they create the power, the legal power for extended storage where consent is obtained and the other circumstances are met. But I'd be confident that the HFEA would expect and would require clinics to protect their patients' interests by giving them the opportunities for extended storage where that was possible and appropriate. So there are two different legal elements to it. One is the statutory requirements or power, and the other is the regulatory expectation and the stick to beat clinics with if they don't follow good practice and contact patients properly. I think there is obviously a degree of discretion and flexibility around how that's done in practice, but patients, in order to be able to provide consent within the law, need to be given adequate information to allow them to make decisions. So if it is possible for patients to consent to extended storage, they have to be given the opportunity to do that. So yeah, I'll have a think about it, Raj.
Okay, and a slightly different question now. What about payment for storage here? This is from Amy Cohen. Do the HFEA recommend trying to reduce the cost burden for some patients who would otherwise have already used or discarded their material, if not for COVID?
Well, that's the question. That sounds like a question for the HFEA. The HFEA don't, or the regulations don't regulate the cost of storage or charging for storage. And as I know some of us have discussed on many occasions, the contracts that clinics have in place with patients requiring them to pay storage fees operate quite separately and in parallel with the consent to storage, which allows the clinic to lawfully store material. So it's very common for clinics to have consent to store, but for patients to stop paying fees, which they're contractually obliged to pay to the clinic to continue to store on their behalf. And they're mutually exclusive. So it's permissible for a clinic to remove material from storage if patients stop paying their storage fees, even though the patients have consented to the material being stored for longer than the fees have been paid. So it's a slightly tricky area, and that's subject to a number of qualifications. But I think the question hints at whether or not, if there's a 2-year extension, those fees should be revisited. But that's very much for clinics to decide how they deal with that, particularly if the delay in treatment is as a result of COVID.
Yeah. And I think we've perhaps got time for one more question, and I don't know whether you've noticed any and been scanning them, James, that you particularly want to answer or to avoid. I'm
trying to keep very still and very loud. I haven't been reading them, but
so let's see. I suppose it's a bit of a. I think this one is if you've lost contact with your patients and they have moved, perhaps moved overseas, and the 10-year expiry is coming up, then how many attempts to contact is deemed reasonable before you end that storage at the end of the consented period?
Yeah, it's a very common problem and challenge, and there isn't a right answer. I think it's well worth making several reasonable attempts using the contact details that you have. I think, if anything, it points to the importance when you first see patients and take their consent to storage, to emphasize at that point that they must notify you of a change in contact details, change of address if they go abroad, and explain to them what, although it may seem very unlikely that this eventuality would be a problem in 8 years' time, that in fact it can be very complicated if the clinic isn't able to contact them. And similar issues arise in relation to non-payment for storage fees as well. So I think both the question really hammers home the importance of conveying this to patients very clearly at their initial consultations. But in terms of the number of times you need to try to contact them, there isn't a strict rule, but I think it's worth trying all of the different ways available and giving it a couple of goes. And it's to go right back to one of the first questions, it's another reason not to leave it to the last minute, that it's far better to make sure that there's sufficient time to allow for a delay in response. And it's always going to be the most complicated cases where people have taken a year's sabbatical and thrown their mobile phone in the river, and so they're not contactable, or they've been in a coma, or they've not been picking up their emails, or whatever. So that, there are lots of different scenarios where it can be very complicated.
Yeah, I think when we were doing our response to the DHSC about this, we were sort of thinking about it, and I probably rather, said, look, there are lots of different legal situations where you have to prove that you've done something to a court's satisfaction. When I was a very, cutting my teeth at the bar, I was winding up petitions, and I had to prove all the different things in order to wind up a company had been done, including sending of registered letters, posting things on outside the premises in a certain size font and all the rest of it. And I suppose there are ways that this could be thought about and something drafted to give clinics the reassurance that they perhaps need when dealing with this, because with this 2-year extension, and it came up in one of the questions, there could be this huge mushrooming in the amount of material that is stored in quite a short space of time that doesn't allow clinics to plan for that in a way that a change to the law, which we all hope is going to come, to make things much simpler, that could be introduced. So I'm going to close the Q&A now, and I might even attempt to reshare my screen because I'm feeling quite brave. We're near the end, and to remind people to sign our petition if they haven't done so already. So I just now need to give James a huge thank you for being the brave soul that he is and agreeing to be our first speaker. Thank you ever so much for joining us on our first event.